Hi everybody, my name is Landon Hodges and I am an attorney with Steinbacher, Goodall Yurchak. In this video, I will explain the purpose of healthcare powers of attorney and living wills and briefly explain the difference between the two documents. Beginning with the healthcare power of attorney. This is a document that most people likely think of when they think of a power of attorney. This document allows for a person to appoint an agent to make medical decisions on the patient's behalf if they are unable to do so. These powers can consist of simple decisions, such as which medications to take and where to receive treatment, to more crucial decisions, such as whether or not to perform a particular surgery. A healthcare power of attorney is not effective unless the patient is unable to express their wishes to a physician, meaning that if the patient can convey their wishes in any way and has not been declared incapacitated, the patient will still be allowed to make their decisions. If, however, there is the lack of ability to make this decision, the healthcare power of attorney quickly settles the question of who will be making this decision to ensure that medical care is rendered that will be in the patient's best interest. Even if the patient is married, the law does not automatically assume that the spouse is the person the patient would want to make the medical decisions in the event the patient is unable to do so. This can lead to confusion and delay at a time where every second is crucial. Therefore, it is important that everyone has a healthcare power of attorney. The living will is a little bit different in that it deals specifically with end-of-life decisions. Unlike the healthcare power of attorney, the living will is only effective if the patient cannot express their wishes and they have a terminal diagnosis with no realistic hope of recovery. As a reminder, the healthcare power of attorney is effective anytime the patient is unable to express their wishes, even if they are sure to recover. The living will exists to outline wishes if there is a terminal diagnosis. Our office includes terminal diagnosis language in our living will that talks about permanent unconsciousness or a coma and a persistent vegetative state. The living will allows for a designated agent to convey wishes under these circumstances. Therefore, it is very important to discuss with your agents what wishes would be implemented in a terminal diagnosis situation. A few things to ensure that a living will addresses are, first, whether or not to receive artificial nutrition, also known as a feeding tube. Second, whether or not to receive artificial hydration and pain relief medication. And third, any specific provisions dealing with a diagnosis of dementia or Alzheimer's disease. One similarity between a healthcare power of attorney and a living will is that they each have a HIPAA waiver built into the document. HIPAA releases are commonly signed with a particular doctor, but that document only applies to that specific doctor. Having this release built into your healthcare power of attorney and living will means that regardless of who is providing treatment or where, the agent will be able to access medical records and communicate with the physician. In conclusion, these are important documents to have as a part of any estate plan, but they vary in the type of powers provided to the agents and, most importantly, at which point they are effective. Please contact our office to set up an initial consultation to discuss your estate planning.